The 58-year-old white judge laughed loudly when the small black girl walked up to the wooden plaintiff's table at the front of the federal courtroom. The girl was 9 years old. She was 4 feet 2 inches tall. She was wearing a simple navy blue dress, white socks, and small black shoes. She was carrying a brown leather briefcase that was almost as big as she was. She set the briefcase down on the wooden table in front of her. She climbed up onto the tall wooden chair behind the table. She had to use her hands to push herself up. Her small feet did not reach the floor. Judge Harold Pemberton looked down at her from the high wooden bench. He had been a federal judge for 19 years. He laughed for almost 10 full seconds. The laugh was loud enough that 12 other people in the courtroom turned their heads. The opposing counsel, a sharp-faced white attorney named Patricia Holloway, tried to hide her own smile behind her hand. "Young lady, I do not know what you are doing in my courtroom, but I am going to ask you politely to step down from that chair right now and let your father's real attorney take over. This is a federal civil rights case. There are rules in this courtroom. We are not playing pretend." The girl did not step down. She did not look afraid. She just calmly opened her brown leather briefcase. She pulled out a thick stack of papers. Then she looked up at Judge Harold Pemberton. Her voice was very small, but it was completely steady. "Your Honor, with all due respect, I am my father's attorney of record in this case. I have been admitted to the Massachusetts State Bar by special permission of Chief Justice Margaret Whitfield, with full federal courtroom standing for this specific case only. The paperwork has already been filed with the clerk of this court 3 weeks ago. My name is Aria Brooks. My bar number is 7-2-9-3-4-1. I would like to begin my opening statement now, Your Honor." The federal courtroom went completely silent. Judge Harold Pemberton stopped laughing. He looked down at the small black girl. He looked at the clerk to his right. The clerk nodded slowly and held up a thin manila folder. The bar admission paperwork was, in fact, already filed. Patricia Holloway was no longer hiding any smile. She was staring at the small girl with her mouth slightly open. Judge Pemberton cleared his throat very loudly. His large face was no longer red from laughter. It was now slightly pale. "Miss Brooks, please, begin your opening statement." Before this story breaks your heart and rebuilds it again, do me one small favor. If you believe a child's mind cannot be measured by the size of her briefcase or the height of her shoes, hit that like button right now and subscribe to the channel. It costs you nothing. Now let's rewind. Because to understand how a 9-year-old black girl had just walked into a federal courtroom in Boston with a special bar admission, you have to go back 6 years. Aria Brooks was born in 2016 in a small apartment in Roxbury, Boston. Her mother, Janelle, was a hospital cleaner. Her father, Marcus, was a self-taught paralegal who worked at one of the largest law firms in Boston. Marcus had grown up in foster care. He had never had the money to attend college, much less law school. But Marcus Brooks had spent 15 years quietly teaching himself federal civil rights law in the evenings at the public library. He had become one of the most respected paralegals in the city. He had personally helped draft over 400 federal civil rights complaints in the last 12 years. He had never been allowed to argue a single one of them in court because he did not have a law degree. He had simply prepared the briefs for the white attorneys at his firm, who would then sign their own names to his work and walk into court as if it were theirs. Marcus Brooks had only one daughter, Aria. He had taught her to read at the age of 2. He had given her his old college-level law textbooks at the age of 4. He had read her Supreme Court opinions as bedtime stories from the time she was 5. By the time Aria was 7, she could explain federal civil rights complaint procedure. By the time she was 8, she had read every single one of her father's 400 drafted briefs. She had also memorized the entire Federal Rules of Civil Procedure Manual. She had also tested with an IQ of 172 at the age of 7, which placed her in the top 1,000th of 1% of all human beings on the planet. 2 years ago, when Aria was 7, her father Marcus had been suddenly fired from his paralegal position. The official reason was performance issues. The actual reason was that Marcus had filed an internal HR complaint about a senior partner using the N-word in a closed-door meeting. The firm had quietly fired Marcus 31 days later. They had also blacklisted him quietly with every other major Boston law firm. Marcus had not been able to find similar work in 2 years. The Brooks family had lost their apartment. They had moved into a 1-bedroom unit on the 3rd floor of a public housing building. Marcus Brooks had spent the last 2 years quietly preparing a federal civil rights retaliation lawsuit. He had drafted every single document himself. The suit alleged that the firm had retaliated against him for filing his original HR complaint. He had been ready to file it for almost a year, but he had not been able to find a single attorney in Boston willing to take his case. The firm in question was one of the largest in the city. Nobody wanted to fight them. That was when Aria Brooks had spoken up at the family dinner table. She was 8 years old. "Daddy, why do not I just be your lawyer?" Her father had laughed gently. He had told her that there was no way for an 8-year-old child to be admitted to the bar. There were rules, 3 years of law school, a bar exam. Aria Brooks had nodded calmly. Then she had spent the next 10 months quietly researching every single special bar admission rule in the entire United States. She had eventually found one. The state of Massachusetts had a very rare and almost never used provision in its bar admission rules called Section 4-7. The provision allowed for special bar admission of a non-traditional candidate by direct petition to the Chief Justice of the Massachusetts Supreme Judicial Court. The candidate had to demonstrate exceptional legal aptitude through a private examination. The provision had not been used in 43 years. There had been no minimum age requirement specified anywhere. Aria Brooks had quietly written a 53-page petition to Chief Justice Margaret Whitfield. The petition had cited her IQ test results, her reading list, her memorized Federal Procedure Manual, and her 700-page personal annotated outline of federal civil rights case law from 1964 to 2024. She had also attached 3 sample legal briefs she had personally drafted on hypothetical federal civil rights fact patterns. Chief Justice Margaret Whitfield, 66 years old, the first black woman to ever serve as Chief Justice of the Massachusetts Supreme Judicial Court, had read the petition that same evening. She had then quietly canceled all of her appointments for the next morning. Chief Justice Whitfield had personally administered a 6-hour bar examination to 9-year-old Aria Brooks in her private chambers 4 weeks later. The examination was significantly more difficult than the standard Massachusetts bar exam. It included 3 full-length federal civil rights essay questions, a complete federal rules of evidence section, and a 1-hour oral examination on Supreme Court precedent. Aria Brooks had scored 96% on the written portion. She had scored a perfect 100% on the oral examination. The Chief Justice had personally signed Aria's bar admission certificate the following morning. The admission was limited to one specific case only: Marcus Brooks versus Whitfield Holloway and Pemberton LLP. Now, in the federal courtroom in Boston, 9-year-old Aria Brooks was standing on her tippy-toes behind the wooden plaintiff's table. She straightened her navy blue dress, and she began the opening statement her father had been waiting 2 years to hear someone deliver. "Your Honor, my name is Aria Brooks. I am the attorney of record in this case. I am also the daughter of the plaintiff, Mr. Marcus Brooks, who is sitting in the gallery behind me. The defendant, Whitfield Holloway and Pemberton LLP, is one of the largest law firms in the city of Boston. In 2023, my father filed an internal HR complaint at this firm reporting that one of its senior partners, Mr. Reginald Whitfield, had used the racial slur N-word in a closed-door partnership meeting. 31 days later, my father was fired. The official reason given was performance issues. The actual reason was retaliation. Today, Your Honor, I will prove to this court that my father's termination was a direct violation of Section 1981 of the Civil Rights Act of 1866, as well as Section 704A of Title VII of the Civil Rights Act of 1964. Thank you, Your Honor." The opening statement had been delivered in a small, steady voice that did not shake one single time. Patricia Holloway, the opposing counsel, was now sweating through her gray suit. She had been told that the plaintiff had no real attorney. She had not been told about Aria Brooks. Over the next 4 hours, 9-year-old Aria Brooks systematically destroyed the defense case in front of 47 people in the federal courtroom. She introduced internal email evidence that her father had quietly preserved on a personal hard drive for 2 years. The emails clearly showed that Mr. Reginald Whitfield had personally instructed the firm's HR director to find a reason to terminate the Brooks problem, exactly 14 days after Marcus Brooks filed his original racial complaint. Aria Brooks then called 3 witnesses to the stand. 2 former paralegals at the firm, both black, both of whom had been quietly fired in the last 4 years after filing similar complaints. Aria Brooks had personally located both of them through a quiet 8-month investigation of her own. Aria's third witness was a 43-year-old white administrative assistant named Diane Calloway, who had worked at the firm for 12 years. She had been Mr. Reginald Whitfield's personal assistant during the meeting in question. Diane Calloway had testified under oath that she had personally been in the closed-door meeting where Mr. Whitfield had used the N-word. She had testified that the slur had been directed at Marcus Brooks specifically. Patricia Holloway had attempted to discredit Diane Calloway during cross-examination. She had asked Diane why she had not reported the incident sooner. Diane had answered quietly but firmly, "Because I was afraid I would lose my job. I have 2 children, the same way Mr. Brooks lost his." Aria Brooks had then delivered her closing argument. The closing argument was 23 minutes long. It cited 14 separate federal court precedents. It quoted the Civil Rights Act of 1866 directly from memory. It included a personal note from Aria herself in the final paragraph. "Your Honor, my father has spent 15 years drafting briefs that white attorneys signed their names to. He has spent 2 years unemployed because he had the courage to report a racial slur in his workplace. He taught me to read at the age of 2. He read me Supreme Court opinions instead of bedtime stories. He believed in me before I knew how to believe in myself. Today is the first day in 15 years that my father's actual name will appear on a brief that wins a federal civil rights case in this courtroom. And I am asking the court to make sure that today is also the first day in 2 years that my father knows the legal system that he loved his whole life is finally able to love him back." The federal courtroom had gone completely silent. Judge Harold Pemberton, who had laughed at the small girl 4 hours earlier, was no longer laughing. Patricia Holloway had also gone quiet. She had not even attempted a real closing argument. Judge Harold Pemberton ruled from the bench. He did not take the case under advisement. He did not adjourn for deliberations. He simply looked at the small black girl in the navy blue dress. He nodded slowly. "The court finds in favor of the plaintiff, Mr. Marcus Brooks. The defendant, Whitfield Holloway and Pemberton LLP, is hereby ordered to pay damages to the plaintiff in the amount of $7 million, plus full reinstatement to his former position with full back pay and benefits. The court additionally orders the firm to undergo a 6-year federal civil rights consent decree with mandatory annual external audits. Court is adjourned." The wooden gavel came down once. The small black girl closed her brown leather briefcase. She climbed down from the tall wooden chair. Her small feet finally touched the floor. Marcus Brooks was sitting in the 3rd row of the gallery behind her. When Aria turned around to face him, her father was crying quietly into both of his hands. The 47 people in the gallery were standing up and clapping. Several of them were also crying. Within 72 hours, the courtroom video footage had been picked up by every major news network in the country. The video of a 9-year-old black girl in a navy blue dress walking into a federal courtroom and winning a $7 million civil rights case became one of the most-watched legal videos in American history. It had over 300 million views in its first 10 days online. Within 30 days, 3 major Hollywood studios had approached the Brooks family about life rights for a feature film. Aria Brooks had personally negotiated all 3 offers herself. Marcus Brooks returned to work at Whitfield Holloway and Pemberton LLP for exactly 1 day. He used that day to personally deliver his resignation letter. Marcus Brooks then opened his own small civil rights law firm in Roxbury. He hired his own daughter Aria as his lead research associate while she finished elementary school. The new firm filed its first case 3 months later. They have now won 14 consecutive federal civil rights cases. 6 months after the original trial, Chief Justice Margaret Whitfield personally invited Aria Brooks to speak at the annual Massachusetts Supreme Judicial Court bar admission ceremony. Aria stood at the same wooden podium where the Chief Justice swore in new attorneys every year. She was now 10 years old. She wore the same navy blue dress. She spoke for exactly 4 minutes. "Ladies and gentlemen of the Massachusetts bar, 6 months ago, I walked into a federal courtroom because nobody else would represent my father. I want you to remember tonight that the practice of law is not measured by the size of your briefcase or the height of your shoes. It is measured by the courage to walk into a courtroom for somebody who cannot walk in for themselves. My father spent 15 years walking in for white attorneys at his old firm. The least I could do as his daughter was walk in for him just 1 time. So here is what I want to leave you with tonight. Marcus Brooks spent 15 years quietly drafting briefs for white attorneys who signed their own names to his work and won cases that made them rich. He never once won a case under his own name. The legal system had decided that Marcus Brooks, a black self-taught paralegal from foster care, did not deserve to argue his own work. The legal system was wrong about all of it, because gifts do not ask permission to exist. The bedtime stories a father reads to his small daughter at the kitchen table can come back to win a $7 million federal civil rights case 15 years later in a courtroom where nobody expected anyone to fight back. Think about the Aria Brookses around you right now. The quiet black girls in navy blue dresses with briefcases that are almost as big as they are. The fathers teaching their daughters to read Supreme Court opinions because the legal system has not given them anywhere else to teach. The poor families building knowledge in silence that the world will eventually have to bow down to. If this story moved you tonight, do me one final favor. Smash that like button. Subscribe to the channel so you never miss the next story. And drop a comment below telling me about an Aria in your own life. The quiet child whose father spent 15 years preparing her for the moment everybody else thought she could not handle. Because the world is full of children whose fathers have been waiting their entire careers for somebody to finally walk into the courtroom and call their name. And the only question that matters tonight is whether we are humble enough to listen when their small feet walk up to the table, even before they reach the floor. See you in the next story.